Everybody, we're just waiting a few more minutes because it takes so long for people to come into the room. And quite a few people registered, so bear with us. We'll just take one more minute. So whatever time it is where you are, welcome and bear with us. All right. I'm going to start us now as people continue to enter the room. So good morning, good afternoon, wherever you are, good evening. I'd like to welcome you to webinar 29 of the Digital Trade and Data Governance Hub and our partners, and who have helped us find such excellent speakers. And so today's webinar is deliberately called Trade Secret because one of the things that we're going to talk about is how intellectual property rules facilitate AI. So trade agreements are where data flows are governed. And so they're where competition policies could be made complementary if governments really wanted to address the untrustworthiness or the problems of AI. And there were rules such as intellectual property rights give firms ever more data. So to discuss these issues, we have two brilliant scholars, Emily Jones of Oxford University and Neha Mishra of the Graduate Institute. So we're going to begin by talking about the role of AI in trade and how AI is changing trade. So let's begin. Neha, could you start?
So good morning or good afternoon, good evening, everyone. And thanks to Susan and her entire team for inviting me to join. It's a pleasure to be here. I'll just start by just giving some ideas or share some of my ideas as to how AI is changing trade, whether it's actually that is disruptive, because we hear a lot about the transformative potential of AI, but is it really the truth, or where are we today? So before I begin, I think it's helpful to just contextualize a bit in the sense that although we talk so much about artificial intelligence, there's actually no operative definition of artificial intelligence that is agreed upon universally. Broadly speaking, it's something that mimics human intelligence, but that can mean a lot of things. So AI, broadly understood, of course, is embedded in a lot of services, goods, technologies that we are using on a day-to-day basis. So when we think about AI and the role that it plays in the trade environment, I generally think of it from two perspectives. The first one is trade in AI-related technologies, and that's pretty broad as well, considering how much of our day-to-day use involves AI, whether it's in our both goods and in services, but also trade in AI technologies in the sense you could trade AI software, you could trade certain technologies such as facial recognition technology, and some of those also raise potentially very controversial issues. But the other aspect of it, and that's also a big component of understanding the interface of AI and trade, is how AI is driving trade in different processes. So for instance, AI is now frequently used across businesses in optimizing supply chains, logistics, customs administration, in natural language processing. And AI is also driving so many markets, empowering so many sectors and creating new business models. So for instance, in the financial services sector, credit services, digital content, e-healthcare, telemigration. So increasingly, you can also see digital trade being driven by different kinds of AI technology. So if you look at that, if you look at the environment from a broader perspective, it seems like AI is definitely transforming trade in many aspects. And I guess one thing I would end the introduction with is to remind about the importance of data as a driver of AI, because AI is data hungry, as Susan also mentioned right at the outset. And I think it's important to realize that the size of data markets also determines the success of AI-driven technologies. And in that context, there are also concerns around data being concentrated within certain countries, certain entities, and broadly that brings about issues of equity as regards getting benefits out of the development of AI. So I'll end here.
Professor Jones.
Thank you so much. And Neha's very nicely laid out the ground there for me, and many of the points I would have made about AI as an important technology in our economies. And it really is, in many of our everyday activities now that we're engaging with. And I think perhaps we should just add on so you've mentioned that it's a general purpose technology that's really underpinning and quite foundational into a lot of our economic sectors. Perhaps you've also mentioned that it relies on data, so it's really much embedded in that wider digital ecosystem. And when we get on to the trade dimensions, I think we really need to remember that. And then just to put on the table the challenges of regulating AI, which are both technical, political, ethical. There's a lot of dimensions to it. So it's a really challenging technology to regulate. If we come to the trade dimensions, I want to flag five dimensions for us as trade policy folk. Data is one of them, and I'll come to that. But I want to put these five on the table for us, and perhaps that can help us structure the discussion. So the first is the need for then AI to have international standards around AI. And we're seeing governments move quite quickly to develop their own regulatory standards and initiatives. But a question there for us in the trade space is the question of to what extent they're complementary and they're coherent. So again, you've mentioned, Neha, there are a lot of trade in AI technologies. So having harmonized or at least common standards and regulatory approaches becomes really important. And we can talk about to what extent we're doing that in a little while, but that's certainly AI standards and standards regulations become really important. The second one, I think this is one I really want to put on the table for us and I think it's been neglected so far, is I think we need far stronger international mechanisms to protect consumers and workers who are interfacing with AI technologies. And consumer and labor protections we've really thought about as domestic in nature. But in today's global economy, we're seeing more and more consumers engage directly in international trade. I might buy an iPhone from Japan, I might engage with a website that's hosted elsewhere. And in so doing, we're engaging with a lot of AI applications that are actually delivered across borders. So consumers, I think we need to rethink consumer protection a little bit more. And similarly, workers. So the gig economy workers are often working for gig economy platforms that are based in another jurisdiction. So if you're sort of fired by algorithm, so to speak, or you're treated unfairly by an algorithm, you want some mechanism for redress, it's not obvious that we've got those international mechanisms. And again, the trade policy community is an obvious place to look to think about how we cooperate around labor and consumer protections as regards to AI. The third one, so the first one then is digital standards. The second, labor and consumer markets as they interface with AI applications. The third is digital competition or competition in digital markets. And that's an issue. We know it's an issue, but it's being driven and exacerbated, Neha, you mentioned it, by AI. So competition policy, competition in digital markets, market power, market concentration are more extreme than we've seen in many economic markets. And again, we don't have the international mechanisms really to deal with that. So that's something else I want to put up there. The fourth is intellectual property. Susan, you've mentioned it. And rightly so, companies who are AI innovators are pushing for protection of source code and algorithms, and rightly so, and they're protecting their innovations. But there's some really big questions then about how we regulate AI and whether the protections we're affording them through intellectual property give enough leeway for governments to regulate. So we can come back to that, because I think we haven't always struck the right balance there in our trade agreements. And final one, which Neha you've put on the table for us, is the data. So that's the fifth and final one. Data being absolutely reliant on AI, and a lot of the questions around who owns that data, how it's regulated. So you need training data for those AI applications to work, and that training data is amassed from all over the world. You also need real-time data flows to make AI work. So as we talk about data regulation, which of course we do in the trade policy community, it's sort of a hot topic. If we're going to benefit from AI, we need that data to flow. At the same time, if we're going to make sure that that AI is unbiased and the data it's using is unproblematic, we need effective regulation. So those are the 5 dimensions I wanted to put on the table for us.
Thank you so much, Em. So in a sense, you've said where trade agreements, the areas that they're missing. And so I wonder if we can't talk about that a little bit more, like what you think trade agreements should include. But before we do that, I want to say we may not have a full hour for everyone here, and the Hub's goal is always to have the audience ask questions. So please start putting your questions in the Q&A, and I will read them out loud to our scholars here. So Emily, why don't you take it from that question I just asked you? And again, just put them in the Q&A, not the chat. Thank you, everyone.
So the question you just asked then, Susan, was you saying, you know, I've flagged a series of areas there that I think where trade agreements are not doing enough, and just sort of say where are we at in this state of play. You're right. I think in terms of trade agreements, I'd love to see more on competition, consumer protection, and labor rights in particular, and I'm happy to expand on that. I guess the big question for us as trade policymakers is whether trade agreements and free trade agreements in particular, or trade rules in the WTO or in free trade agreements, are the right space for this conversation. I'd love to hear what you think, Neha, on this, but, you know, as AI has got so many ethical dimensions to it, you know, the trade policy community is not always set up to think through the human rights and ethical implications of a technology. So, for example, if we think about the development of new international standards, are they an unfair trade barrier, right? If that's a question that's put before the trade policy community, are they well set up to adjudicate between a sort of unfair protectionism or a legitimate protection of human rights? We're not always in the right regulatory space. So I think there is a question there as to whether, or to put it the other way, I think we absolutely need an international dialogue on all of these dimensions. The question is whether trade agreements, as we've traditionally known them, whether the fora we have are the right place for it. And a theme I'd love us to come back to, Susan, but I think some of my concerns at the moment are that industry is the most articulate voice on this. Industry really understands its interests, understands its needs, is able to articulate them. Do we have the right inclusive processes that involve consumer groups, labor groups, and others to really get a good outcome at the international level that's public policy, aligned with public policy interests? So in thinking about how we govern this space, inclusivity and making sure we've got all the voices at the table also becomes really important.
Well, the inclusivity of developing countries that may or may not have capabilities in AI is also a key issue. Neha?
Yeah, I think just to follow up on Emily's point, she covered a lot of areas that I have been also writing on in terms of what especially the new generation of free trade agreements are doing. But I think it's also good to just take a step back and also highlight that there are certain fundamental issues in trade law which still remain uncertain as regards how they apply to AI-driven trade or trade in AI products. So there's some very traditional issues, but which haven't been resolved, which still continue to be a part of the dialogue. So for instance, in trade law, there generally tends to be a divergence between disciplines that apply to services and those that apply to trade and goods. And there has been this consistent dialogue that there needs to be more convergence. And AI is a very good example where if you try to look at the services and goods distinction, it completely falls apart because, you know, it sometimes may not even make sense because AI is embedded in so many goods that we use on a day-to-day basis. So there's some very fundamental questions like that. Another fundamental question is, how do you classify AI technologies under the services as commitments that countries make on trade and services? So that's another traditional issue, I think, which, you know, this has been an ongoing debate for decades, like last 20 years, but still these questions remain very relevant, and even so much more with AI technologies. I think with respect to what has been shifting in some of these recent trade agreements, I know Emily mentioned both about source code, algorithmic disclosure provisions, and I know there's also a lot of focus these days on what the new age digital economy agreements are doing in terms of bringing in more disciplines to address emerging technologies and AI, and especially seeing whether that can be an avenue for regulatory cooperation among trade partners. So I think that's a direction in which a lot of dialogue is now concentrated. I'm a little more skeptical about trade agreements being a site for discussion for certain human rights issues or certain labor issues, because that relationship has always been problematic. Where I think trade agreements can take a step forward, especially when you look at some of the new digital economy agreements, is to acknowledge that there are standards and norms out there outside the trade world which are trying to develop certain common principles and incorporate them by reference whenever it's relevant. So part of my writing has been to see how trade bodies can be more open to these multi-stakeholder processes that don't necessarily happen in the same way as multilateral processes, but where the norm development can be quite important, and where if you think of consumer groups, you think of businesses, or you think of governments, they can all come together and discuss some of these issues more transparently, perhaps without the same limitations that come with a multilateral process. But at the same time, it remains, it's not something you would doubt that there is no consensus on these issues at a global level, and different countries think very differently about AI technologies and how to regulate them. And to some extent, when it comes to protectionism in that sector, some trade disciplines could be relevant if there is clarity around how they could apply to trade in AI technologies. So going back to very standard issues of whether there's market access, whether you're trying to protect the intellectual property of innovators, at the same time looking at the limitations that they face in particular. So for instance, source code and algorithmic disclosure, which is such a big debate these days. On the one side, it is important for protecting proprietary interests of companies. On the other side, there are questions whether it's going to harm algorithmic accountability that governments want to enforce. And we don't really have clear answers, because we don't even know to the extent to which access to source code and algorithms can solve all the regulatory dilemmas out there. Perhaps there are certain questions that access to source code by itself isn't enough, and there are broader questions around what other interventions are necessary to address these issues. So yeah, these are the broad range of issues that I think trade agreements are trying to deal with. Some of it I don't think they can deal with because it's outside their scope. But yeah, certainly some issues which are very core trade related issues, there is more avenue for discussion. And also, as I said, that this could be a very good site for regulatory cooperation, and acknowledging relevant standards, whether it's at the OECD or at the Global Partnership on Artificial Intelligence, wherever it's happening, to acknowledge them when it's necessary to build trust between countries on different issues, like say data flows, on the right principles for AI technologies, development of AI technologies, responsible use of AI technologies.
Thank you, Neha. Do you want to add anything right now to what we were just talking about?
I was just to echo Neha's point, to give a couple of examples of where we're seeing things move quite quickly, because I'm sitting in the UK, and it's been really interesting to see the UK first identify digital trade as a real priority. And then within some of our recent trade agreements, so the UK, Australia, UK, New Zealand, and most recently, we've got a new standalone digital economy agreement with Singapore. And there actually, we've seen quite an interesting development in a few spaces. So with the Australia agreement, the emphasis really was on sort of promoting data flows and on innovation in AI. And I think what was interesting was in the Singapore, we've seen the same sort of promotion of AI and regulatory cooperation and research and development, but a little bit more emphasis on actually thinking through and cooperating with regards to regulating AI, with regards to ethics, biases, and addressing some of the harms that arise, and some novel provisions there on competition as well. So again, they're quite sort of soft obligations. They're really sort of looking to have a dialogue, but at least we're getting that space open up. So I think it's been encouraging to see some of that development.
Agreed. And one thing that I've seen very little on, I know we have folks from the OECD and the WTO here, is a discussion of what are barriers to trade in AI. What, like issues of like product, is trustworthy AI? A product that is different from regular AI, whatever trustworthy AI means. Okay, we have 16 questions, so our speakers are so smart, we're going to just wing it right now. And let's start with the first question. So this is directed towards Neha. What evidence is there to support your statement on concentration of data in given markets?
I don't have any data with me at the moment. I doubt there is a lot of data on data markets. I'm not entirely sure about that. But at the same time, what I was trying to say is that there are certain big players in the market, big technology companies, and they tend to have a huge customer base, which makes it easier for them to get access to data of millions and sometimes even billions of customers. And when you have more data, it's easier for you to design more customized AI products. So yes, if you that kind of perpetuates the some degree of inequity in the market. So that's what I was trying to get at, nothing beyond that. But I think that's another issue, the extent to which data markets are transparent. And I think there isn't much statistics, at least that I'm aware of, that on the basis of which you can talk about transparency of data markets and who's holding how much data about whom and where.
Yeah, UNCTAD has had some data on that.
Yeah.
The digital economy reports. Do you want to add anything here?
Just to come back on that, I mean, data is fueling our global economy in many ways, and yeah, there's a real opacity here, and a genuine challenge of actually how we identify data, how we measure it. So I think that's one of the big challenges for all of us, is to really get a handle on the magnitude of these flows and their value, and then think about the questions about ownership. So again, perhaps on the data question, I think there's a couple of interesting aspects. So one statistic perhaps to share, which was a McKinsey report back in the day, which we all use because there's no other data points that are really obvious and they're out there. But the McKinsey back in, I think, 2016, in their digitalized global trade report, estimated that the value of trade is greater than the value of trading goods now. So in terms of data flows being at least equally important for our global economy, which, if true, is an astonishing point. And if that was back in 2016, I mean, clearly things have grown since, but we need to get a handle on this. And then perhaps the second point is to look at some of the innovations again around, we talk a lot in our trade policy community about data protection and privacy, and that's really important. But there's been some interesting reference, again, I'll go back to that Singapore UK agreement, to data trusts and exploring ideas around data trusts and data ownership. There are provisions on open government data, but also there's questions about data portability. So again, these questions about who owns data, who's got access to data, and all that's important for all of us in the AI space in terms of thinking about who gets to innovate. And you only get to innovate if you've got access to large training data sets. So data, again, becomes really important.
Okay, next question. Thank you for that response. Is there any measurable effect that AI has had on international trade relations? So do we have any numbers on, or just using proxies, estimates? Neha?
Well, I would say we are still relying on proxies, and I think that's what Emily and I emphasized as well. It is hard to measure data flows. It's very hard to measure what kind of data is being generated by AI and what volume of data is being used by AI on both fronts. So I think, at least to the extent I'm aware of, I don't know if there are any numbers, but it's omnipresent. So you would imagine something that is omnipresent sometimes becomes very hard to measure because it's everywhere. And sometimes when something is everywhere, it's nowhere because you don't know how to exactly estimate where it is. But I would say I am not aware of anything beyond some of these proxies that we have used to explain.
Thank you, Neha. Okay, this next question is on intellectual property. I am not, but I'm reading this question. I am an intellectual property expert, and I'm puzzled by the idea that algorithms should be protected, i.e. there should be monopoly rights in algorithms. Algorithms have traditionally been excluded by definition from both patent and trademark. So we're going to need to talk about trade secrets and how and why trade agreements protect algorithms. Emily, can you go first?
I'd love to have a better understanding from our questioner actually as to the rationale historically as to why IP has excluded algorithms, because I'm coming to this as a trade policy perspective. And what we see there is we've had a lot of lobbying and successful lobbying by tech companies to say they want their algorithms and source code protected. And the reason has been that we've got some governments requiring the disclosure of source code and algorithms as a condition for market entry. So there's tech companies that then said we want to be protected. We're not protected under traditional IP rules, as I understand it, which correlates with the question. Therefore, can we have some very specific provisions in trade agreements that protect algorithms and source code? So we've had since 2015 the introduction of very specific provisions aimed to do exactly that. But the question, the way that the questions frame suggests that actually that might not be, from an intellectual property point of view, we might not need, what's the justification, I guess. And to be honest, I'm not sure what the public policy justification is. Certainly from a trade policy lens, though, the requirement to disclose algorithms and source code has been driving this. So we're back into the realm of geopolitics.
Neha, do you want to add anything?
So the law on trade secrets can, theoretically speaking, protect algorithms as long as they have a commercial value and remain secret in nature. That's something that has also been acknowledged in the TRIPS agreement, and that comes from intellectual property law as well. So I'm not sure that. So even if you were to not, kind of not take into account the new age provisions on source code disclosure and on algorithms, which was introduced much later by the USMC and some other agreements. Even when you look at the disciplines on trade secrets, there is an argument to be made that to some extent algorithms could be protected as trade secrets, provided they meet those requirements under the TRIPS agreement. And there are exceptions to it as well, which are set out in the TRIPS agreement. So for instance, if there is an overriding public interest, then of course, some of these protections to trade secrets may not apply. So I think that's one aspect, that trade secret, and many countries have laws on trade secrets. Not all countries do, but many countries do. So that's one layer of protection that's already available. I have seen some literature recently questioning this provision on source code disclosure and why there needs to be this third layer of protection when they already have other layers of protection. And this kind of affects algorithmic accountability that governments need to do because there's so much bias in algorithms and misuse of AI. My response to that is, well, there are two ways of looking at it. One is that many of these provisions on trades on source code disclosure come with their own exceptions, and sometimes they are really broad. To be honest, some of these FTAs, the provisions are so broad that they don't really protect anything. So that's one aspect of it. The other aspect of it is just to think in the context of what do you really gain by, so on the one side, you are trying to protect, proprietary interests of companies. You're trying to protect them against trade secret theft in certain countries where perhaps, they can take the technical information and give it to a local company who might reverse engineer and start making copycat products or whatever, so concerns around that. But the other side, you also have to think about certain benefits that might come in terms of preventing governments from misusing certain technologies to target certain citizen groups or certain dissidents within the country. So it also generates trust that that the algorithms that the company is using is something that it's within their control. The governments don't have access to some secret key based on which they can track you, or so there is a trust element to it as well that this provision brings in, which sometimes I think is also important to take into account. And from a technological perspective, I think I'm not an engineer, but my understanding is just access to source code does not always give you perfect information as to how the algorithm is going to work in practice, because there are many other things that, so for instance, an algorithm could be a self-learning algorithm, in which case, even if you have access to the source code, and even if you get access to the algorithm and all the data that the algorithm is using, you might still not understand how decisions are being made. So in that context, you need to also think about other ways of verifying algorithms, the robustness of algorithms, and not just having a legal provision, because that can be a false layer of protection in some ways.
That is such an important point, but I do think, and I wonder what both of you think of this, that, you know, the historic norms of the WTO or of trade agreements are in a sense so challenged by the opacity of AI, the black box nature. And I'm really grateful to you to pointing out the two sides of the trust equation there. You know, it can be positive, but it could also be very negative. Okay, our next question is directed towards M, and that is, how does the protection of labor and consumer rights require scrutiny of algorithm?
Yeah, thank you so much. So it's less, I think it's less the scrutiny of algorithms than your recourse, your ability to have recourse. So if, for example, I don't know, I'm a gig economy worker working in Ghana, and I'm providing my labor through a gig economy platform based in the US, and then I'm fired by the algorithmic decision. What's my recourse for then making sure that that algorithm has treated me fairly? So the Ghanaian regulator, the Ghanaian regulator is in charge of my sort of labor rights, has got clearly no recourse then to that platform if it's based overseas. And we don't have any international mechanism at the moment for facilitating that cooperation. So it's not clear that the US has got any responsibility towards that Ghanaian worker, and the Ghanaian government, which does have the responsibility, doesn't have the tools. So I think it's just to underline that we've got workers now engaging in the digital economy in international trade. In effect, they're selling their labor via platforms all across the world, and algorithms are managing that labor flow. So actually, what is the mechanism for recourse and redress when they're treated unfairly, and who's responsible for that? And then there's an analogous, I think, situation in the consumer markets where, again, if we're buying off a website that's using AI, if we interface with chatbots, whatever we're doing, if we're buying an autonomous car that's managed, for example, from Japan, and I'm sitting in the UK, there's a fault with it, what's the mechanism for consumer redress? So I think it's really thinking about our consumer and labor provisions in a way that we haven't before. I hope that's a little clearer.
Thank you so much. Neha, do you want to add anything to that?
No, but there's just one point. In some of the FTAs that contain a provision on source code disclosure, there can be an exception that governments might require access to source code to the extent that it's needed to bring about some modification to the source code. And for instance, the examples Emily mentioned could be such kind of examples where there could be some bias in terms of how consumers are treated or laborers are treated, and that could be a way in which you can use the exception that is there within some of these new FTA provisions on source code disclosure.
Thank you so much. Okay, our next question is, what recent trade agreements beyond UK, Singapore explicitly cover AI? Anyone want to take?
So I can answer. Or Emily, please go ahead.
Go on, because I'm very UK focused. So you
okay. There are some recent agreements. So there's the Singapore-Australia Digital Economy Agreement, which we already spoke about. There's the Digital Economy Partnership Agreement, which is between Singapore, New Zealand, and Chile. And the UK-New Zealand FTA as well has provisions which are very specific to AI. And I think we both have already outlined that these provisions are very soft provisions, high-level provisions on regulatory cooperation, taking into account some basic norms in AI ethics. Often, I think the UK-New Zealand FTA refer to the OECD principles as well. And I think most of these agreements are kind of building on some of the deeper chapters on AI and emerging technologies. So I would say these are the ones I am aware of where there's a very explicit AI specific focus. But the question on standards, maybe Emily might be better placed.
Emily?
So just on the, I'm just going to add the UK Australia to your list there as well, which has got very explicit AI provisions in it. But I think the foundational ones, it's the DEPO is the sort of new generation, right, in the digital trade space. So that agreement between Chile, Singapore, and New Zealand really has set the bar. And I think the UK ones, the recent UK ones, very much build from that, and the UK and the Australia, Singapore. So I think Singapore is quite a first mover in this space, and it's really interesting to see Singapore moving. what's interesting is that neither the EU or the US have got are at the forefront at the moment. So I think they're trying to get their domestic house in order, and actually it's some of these middle economies that are moving quite fast in the trade space to start codifying, albeit at a very early stage.
That is such an important point. If I could be a selfish person and say that the OECD maps this, because countries voluntarily report on what they're doing, and the Digital Trade and Data Governance Hub, where you're at, maps it as well for 68 countries in the EU. So there is some mapping of what's going on, but not enough to really answer the next question, which is, are there governments that are leading in setting AI standards? Who's to decide what is leading?
So I'll jump in on this one, because it was a really interesting discussion at the moment. I don't know if you've been following, but on the geopolitics of who's going to be the next head of the ITU, the International Telecoms Union. All to say, I think there's some interesting and quite technical discussions going on at the ITU, but also in other standard setting bodies that, quite frankly, a lot of us are not that familiar with. They're quite often industry bodies that deal with quite technical, detailed technical standards that are really just technical in nature. You know, what health and safety standards should a toaster have? That we often don't, from a broader trade policy community, get involved in. But I think these questions around frontier technologies like AI are absolutely, they're happening in the same quite opaque, often digital standards bodies, where there's very little public oversight and accountability. And yet they're quite important. And the big tussle there and the big race is between the US and China. And China's maneuvered quite effectively and is now heading up a lot of the important standard setting committees within these international bodies on digital technologies. And I think we're seeing at the moment this question about who's going to head up the ITU. I don't know if I've been out of things.
So the US candidate won the ITU elections, I believe. That's
Okay.
my information.
It was like 162 to 25, but
Yeah.
it was probably a bit tainted.
Yes.
Russia's recent behavior. Our next question is, why is policy trying to catch up to AI technology? Shouldn't the policies have been in place before? Neha, want to give that a roll?
Well, I think between law and technology, there's always been a cat and mouse game. And perhaps one argument to be made is that regulators may not even know what shape and form AI or any other new technology might take in the future. So preemptive regulation, the traditional argument is that preemptive regulation can often hamper innovation. Having said that, I think there is some need for regulate. So just because there's AI technology or some other new technology doesn't mean that the laws that we already have in place don't apply. They do apply. The challenge sometimes is when these new technologies just change or completely disrupt the way in which the world works, in which case then law kind of falls behind. So I would think that there's no way that any regulator would be able to have, can preempt the growth of technology and then have a policy framework in place. Yeah, that would be my sense for any technology, not just for AI.
Thank you so much. Can you talk more about the actors that you think should coordinate on trade agreements? I guess digital trade agreements. Can you take that?
Yeah, let me just come back on the previous question as well, because I think there is this perennial problem of regulatory catch-up. And regulators always they're always behind the technological curve. It's very hard not to be. And actually, I think what's important from a public policy perspective is often industry understands the new technologies in a much more sophisticated way than government. And actually a bit of the challenge is making sure you've got enough expertise on the government side to really regulate effectively and really strike that balance between, you don't want to over-regulate and dampen innovation in what's an important technology. At the same time, you want to make sure that it's fulfilling its sort of social and economic responsibilities. And we see this, for example, in the financial services sector. We've got really fast innovation and financial services regulators have really struggled to keep up. And I think there's an analogous situation happening in the digital space. But just the question you just raised, repeat it for me, Susan, sorry.
Of course. Can you talk more about the actors that you think should coordinate?
Yeah. So the UK is an interesting space here. So we've actually got a digital regulators forum set up nationally, because it was recognizing that actually not everyone coordinates effectively at the national level. And I think we need an analogous situation perhaps at the international level, but that is to make sure that our competition authority and consumer protection authorities are talking to our business and technology ministries, are talking to our trade ministry, and actually foreign affairs and security. So a lot of these very in defense. So sort of these new frontier digital technologies also have security implications and cybersecurity implications. So we need a lot of joined up government at the national level to regulate these technologies. And again, we need an analogous, I think, joining up at the international level, and not just leave everything to the trade policy folk. With some of these big technologies like AI, we need a lot of different voices around the table. And the problem seems to be, to me, that we're having siloed discussions quite often. So there might be a discussion at the UN on AI principles, or at the OECD, that's not necessarily nothing sort of joining up with the conversations that we're having in the trade policy space. And that's all within government machinery. And then I think we really need to think quite carefully about how we involve industry, and how we involve citizens groups, consumer groups, and labor groups, who are often lacking in the resources to really understand these technologies as well, and identify and articulate their own interests.
Thank you so much. Do you think that cooperation on conformity assessment through mutual recognitions or accreditations of AI systems could be a way to facilitate trade? Neha, do you want to start with that?
Yeah, actually, that's one of the points I had put down in my original notes, that I think that one of the role that trade agreements can play is to build more consensus around conformity assessment procedures for AI products. So for instance, I had read a while back that there was an effort being made to develop an AI seal. And the idea behind this AI seal was that if there's an AI product which is compliant with the basic ethical norms of AI development, and that's throughout the AI life cycle, from designing the product to deploying the product and then monitoring the AI product. So if there's some kind of mechanism like that, then you could have a product which has an AI seal, and that could, even though different countries or different companies might use different technologies, you could still come up with some kind of mechanism by which you can create a trustworthy a channel for trustworthy trade in these products. Having said that, there is also a lot of doubt on whether such a mechanism can be possible, because some people think of AI ethics and the entire project around as just whitewashing by the private sector, and not really about compliance with ethical norms that are necessary to build trustworthy AI products. But having said that, I think and there is experience to be gained from the practices under the TBT agreement, which sometimes people forget that there is experience in other areas, not necessarily in digital products and services, but in other areas that can be quite relevant when we think about standard setting in AI, and also about conformity assessment procedures in AI. So yes, I would think that is one of the areas where there is potential scope for trade agreements to contribute.
Thank you so much. So here's a toughie. Could we address the implications of AI as a service supplier under the GATS? For example, legal bots, or any kind of bots, disinformation bots. If there's a requirement to be registered to a bar to provide legal services, including through Mode 1, presumably a member could ban legal bots without violating their GATS obligations. Any thoughts?
That's one for we need the trade lawyer on this one.
So if I understand the question, it's a question around how you classify legal bots, right? If you classify legal bots as something that provides legal service, and if you have made a commitment, or if your GATS schedule does not make any commitments for legal services, or if the requirement is that you have to qualify in the local jurisdiction to provide legal services, there could be an argument theoretically, yes, it's possible to make that argument, but I'm not sure the extent to which you can equate legal bots to a legal service provider in a more traditional sense. I think there was some work around this. I can't remember who, but I remember reading some scholarship around this, precisely around this question, and examining whether legal bots would qualify as falling within the scope of legal services under the GATS framework, or under the other all FTAs might have their own services classification framework, and they usually rely upon the same framework as the GATS. So yeah, I think yes, it's possible. It's possible you can ban it without violating, but yes, it depends on what the legal bots does, how you classify, and the interpretative questions that arise in that particular case, and the kind of commitments the country has, that specific country has made in their schedule on services.
Thank you. Does the ever-expanding scope of security undermine the ability of trade law to protect the free flow of data for AI? Giving an example, China's cybersecurity law and what the United States is doing regarding CFIUS on export controls or bans on foreign investment in data-sensitive areas. Do you want to give that?
Sure, and here I think it's helpful for us to think about, if we have no regulations at all with regards to sovereign to security, we've actually, I think, undermined trust in the digital economy. So we both want, at the same time, if we've got very stringent national rules around data and digital, we get this sort of situation where we're really impeding cross-border data flows. And ideally, in an ideal world, what we want is a set of norms that we all agree to, which it's incredibly hard as it may be, but that really look at a secure and safe and trusted set of data flows that where we're agreeing on both the rules to which data should be governed, as well as sort of cyber rules that will underpin all our digital economy. But the problem is, at the moment, because we don't have that, what we're seeing is countries then move to regulate nationally and put up barriers to trade, which of course then undermines precisely the data flows and precisely the flow of technologies we need for AI. So we're stuck in quite a difficult space, I think, at the moment. That said, I think perhaps China and the US is where the tensions are highest. That we can, I think, those countries aside, there's a lot of scope for creating effective digital regulations, effective data regulations that will enable AI and make sure that it's trusted and the data is trusted.
Neha, do you want to add anything?
I would also go back to the language of the which has been followed in several trade agreements. But if you look at some of the recent agreements, such as the RCEP, to which China is a signatory, it has, one, the e-commerce chapter is not subject to dispute settlement, but two, the security exception is a completely self-judging exception. And that's very different from the security exception under the WTO framework. And there has been some recent recent disputes. The panel has also clarified that it is not a self-judging exception. There are certain specific requirements that you need to satisfy, and it's only when you satisfy that you can invoke the security exception. So that's another thing I would point out, is that the changing nature of security exceptions, and perhaps cybersecurity being one of the concerns that's leading to this more open and flexible wording of security exceptions.
Thank you. Okay. Another question, I've kind of moved down the field just because we are running short of time, looks at quantum computing. How would you add quantum computing to this question of how AI and trade agreements as an input into comparative advantage in AI? Any thoughts?
Only to say that it's another of these really transformative technologies that I think everyone's trying to get their heads around. Actually, if you look at there's much less known, I think, in the policy world than there is about AI. Actually, I think AI has been around longer. And so again, I think we're going to face the same questions of just, what is this new technology? How do we best regulate it? What are the ethics around it? And then again, these perennial questions about how much we can move at a national level and how much we need to actually be having these discussions at an international level. So I think a lot of the discussion we're having around AI applies to these other frontier digital technologies. and just the need to try and work in collaboration, in coordination, so that we don't get a really fragmented regulatory landscape.
And yet, it looks pretty fragmented. How would you apply source code protection exceptions in trade agreements, for example, for public interest use to researchers, journalists, consumer organizations trying to identify and exploit bias in AI systems?
So that's a really good question. And I think we'd have to go back to the specific wording, but if you look at some of the CPTPP, for example, wording of the exception around source code and algorithms, it was really narrowly crafted, that only a few government bodies were able to then require companies to disclose algorithms and source code. So I haven't got the wording to hand, but I think what's encouraging is that over time, we've seen slightly more expansive public policy exceptions being, so the wording, for example, on some of the more recent ones allows pre-screening, allows a greater number of actors to require source code and algorithms to be disclosed. But I think still there's a really open question of whether that provides enough flexibility. So for example, if you're a third party group, citizens interest group, a labor union, and you want to sort of interrogate that algorithm, do the trade agreements and do the exceptions in them provide some scope? It's as yet unclear. So I'm not sure we've got sufficient regulatory leeway and space in some of that source code and algorithm drafting.
Yeah, and it brings up another question, which is, you know, in the past 2 weeks, we've had both Facebook and Twitter reveal that they have no real understanding of the data that they've already collected, let alone what they currently collect. They don't know where it's stored. They don't know how to protect it, et cetera. That's a really strange market for trade. I wonder if you have any comments on that.
Only that I think, going back to Neha's point earlier, Neha, you were saying that how opaque these markets are, right? And it's astonishing that we've got so much data that's fueling so much of these technologies, and yet we really don't have clear oversight. I mean, the other thing related to that always astonishes me is how little regulation we have over data storage facilities. Again, data centers aren't particularly well regulated. It's a lot of it's industry self-regulation. So a lot of the deep underlying infrastructure, whether it's the data itself, we don't know quite how big it is, where it's stored, and actually the storage facilities, we're not necessarily regulating effectively either. We're hoping the industry is doing their part, I think, and a little bit too much.
Okay, how do export controls on chips, how might that affect market shares and growth or firm investment in AI? Does anyone have any sense of that? Okay.
That'll be a no from us.
So we're going to go with one last question about disclosure to regulators and the opacity. What is that relationship? Can anyone talk a little bit more about that?
Only hypothetically, which is less from a sort of actual what we know from practice, but that actually there's a real potential to be gamed here, right? There's a real information asymmetry, a really serious information asymmetry, where the owners of algorithms, the owner of those data sets, if you want to scrutinize the data they've used, the algorithm they've used, essentially they're holding all the cards. And as a regulator, it can be quite hard to know whether you're being given the correct data. So you might be given an unbiased sample of that data. You might be given, so the algorithm can be rewritten. I mean, we've seen this in the financial services sector. It can be incredibly hard for regulators to effectively regulate and to know that they're not being gamed. And I think that's going to be the big challenge coming up, is precisely that. So I think it's a challenge for governments. I think that's why we need the cooperation in this space, because if governments can work together, they've got much more chance of finding effective ways to regulate.
Okay, any short final statements that anyone would like to make?
Oh, so one of the things I was thinking when we were having the discussion is that we're talking about AI. We used to talk about big data, Internet of Things. We'll soon probably be talking about quantum computing, metaverse. But all of this, I think, at the end of the day, there are some very fundamental questions, some of them around very basic things around data governance, which keep coming back, and also the need for technology neutral regulation to the extent that is possible, because it is, after all, a very ideal goal. You may or may not reach it, but that's the thought that I had in my head, that these technologies keep changing, and it is very hard for to get a hold on and understand each of these technologies, and especially for regulators who are dealing with so many complex issues at the same time. So I think going back to the fundamentals would be very helpful, both as for us as researchers, but also for the broader policy community, to get the fundamentals right.
Did you want to say anything else?
Yeah, I think my last word for all of us is to think about who's making the rules and making sure that it's inclusive, because all too often we're perhaps deferring decision making to those who know most, because it's a really complicated area, but those who know most are often in industry, and they've also got their interests. So really, to safeguard the public interest in this space, making sure that we've got all countries at the table, but we've also got the different actors within countries at the table.
Thank you so much. I just want to tell you that our next webinar will be November 1st, and we have the CEO of Unanimous AI, which is a form of swarm AI, and which is essentially a form of crowdsourcing people's opinions. Could be very useful to more political participation and inclusion. But the CEO is going to talk about human rights and XR, using AI as a component of XR, and I hope you can join us. I want to thank you all so much for joining us today. I want to thank our speakers and our co-organizers at the Graduate Institute, at CG, and at GWU. I hope everybody has a great weekend, and please come see us again. Thank you so much. Have a great day, everybody. Bye.
Thank you. Bye-bye.
Thank you.
Everyone.